All right. All right. So, public defender number one.
Yeah.
Alex Settle. So you are the county public defender.
So I am one of the public defenders in the county.
Yeah.
So I am the first assistant deputy public defender in Atlanta County. So I work right underneath the deputy in Atlanta County. There's a number of different public defenders there. We're all assistant public defenders. There's around 15 of us. And we handle probably, I would say, about 90% of the indictable, the felony cases in Atlanta County. So the majority of the people that are in the Atlanta County Criminal Court are going to be represented by the Public Defender's Office. The reason being is most people are usually like one life event away from qualifying for a public defender. I mean, typically, public defenders represent indigent people. Most people, if they get charged with an indictable felony offense, there's some consequence to go along with it. If they're incarcerated for even a few days, they may end up losing their job, right? If their job finds out that they were charged with certain crimes, they may end up losing their job as a result of that, even if they aren't jailed. And sometimes it takes 6 months, 12 months, even rare cases, 2 years for them to get indicted. They're not working. Bills are starting to pile up. They don't have any money to pay an attorney. They usually qualify for the Public Defender's Office. And we've represented everybody. I mean, doctors, nurses, union workers. I mean, pretty much any kind of profession that you can think of, or anybody that's been employed in any field.
How does a doctor qualify?
Well, I mean, if you're a doctor and let's say your license is suspended and you're not able to work and you haven't been indicted for several months or in some cases several years, you're not working, you've burned through all of your assets, you have no money. You were a doctor at one point in time, you haven't been able to work, you may end up qualifying for a public defender.
Do you have to prove no money or just no income?
Well, both, right? So they do what's called a 5A, and that 5A analysis shows whether they qualify based on the poverty guidelines. So poverty guidelines come out every year. It depends on how many members in their family that they're responsible for, how many dependents that they have, and then a percentage of that. They use a calculation, and that makes the determination if they qualify for a public defender. So it's based on income, yes, but also assets. If they have assets and they have assets that they could sell in order to pay for an attorney, and they're expected to sell those assets and pay for an attorney.
That's unbelievable.
Yeah. I mean, otherwise you won't qualify.
90% of the population qualifies in Atlanta County?
I would say probably about 90% of the people our office represents.
Would you say that's is that is that scalable to New Jersey?
What do you mean?
Well, you said Atlanta County, 90%.
Yeah,
is that scalable to all of New Jersey?
I would say most of the counties in New Jersey, yeah. Our office represents
the country?
A significant proportion of, New Jersey specifically.
Yeah.
I don't know about what qualifications are in the other states. Other states don't have public defender offices that are, quite like ours. Like ours is considered to be one of the model public defender's offices in the country. Jen Saletti's the public defender. She's done a fantastic job of kind of building the office and having a lot of experienced attorneys there. And, she's taken the initiative of taking it a step further. Not every state has a central public defender's office. So, for example, years ago, I know Maine, they operated on what's called like a pooling system where they have private attorneys and then indigent clients, poor clients, their cases were farmed out to their attorneys, but there wasn't an actual public defender's office. Mm-hmm. So we have an office. There's a public defender's office in each one of the counties. Our main office is in Trenton. That's kind of like the central hub.
Mm.
Yeah.
So the reason I was very excited to have you here, right, is because I'm friends with a couple people that are in the prosecutor's office, right?
Yeah.
And a buddy of mine was telling me a story about this guy. He allegedly,
always allegedly,
he murdered some girl.
Allegedly.
Murdered some lady. I said allegedly first. We don't have to continue to allege it. Yeah. So murdered some lady. Facts of the case came out, whatever. It was pretty much like what I think the prosecutors would consider a slam dunk based on the facts of the case. The guy gave them consent to have their phone. So they said, hey, can we have your phone? Can we dump your phone? Yeah, no problem. Go ahead. They had his phone. Some type of technical issue prevented them from doing a 100% dump of the phone. The guy comes back to the office. Hey, I need my phone back. they said, kick rocks. We don't have all we need out of it. We're gonna, you know, they get a warrant for the phone. Some time has passes between when he asked for his phone back and when they obtain the warrant. They dump the phone in the meantime. They get everything they need. They have 100% proof where the woman's body was dumped. There's GPS just takes her right there from his phone. He gets convicted at trial, goes to appeals, and the appellate court agreed with the defense that he was improperly searched and seized because they never gave him the phone back. Right. So when he comes back to the prosecutor's office, said, "Hey, I need my phone back," they are required to give him his phone back because he gave them consent to search his phone. When he removes consent, they don't have permission to have that phone anymore. They got to give him the phone right back unless they're in the middle of something.
Yes.
Correct.
So basically, they had an obligation that once you revoke consent, they had to turn the phone back over, or they had to then secure a warrant, right? So just generally with the facts of the case, so basically what happens is, he's cooperative, speaks with them, provides them consent to search his phone. They search his phone. They didn't get all the data off of it that they wanted at the time, and he revoked his consent. They refused to give it back to him. They then searched the phone again at a later date. He still requested his phone back over and over and over again, and still refused to give it back. And then some months later, they ended up getting a warrant to search it. And that was one of the issues that came up on appeal, was an unreasonable seizure of the phones, because the Fourth Amendment protects against unreasonable searches and unreasonable seizures, meaning there has to be a basis to seize it for a period of time. The other thing is with regard to the evidence of the case, the misnomer is that there was turn-by-turn direction that came right from the body. That was 3 miles plus down the road. It wasn't actually where the body was located. The other issue that they addressed on appeal that they didn't reach because they reached the search issue was the issue of improper net opinion by one of the experts. So the whole theory of the case was the investigators came out in the morning. It had snowed the night before. There was snow all over the roadway. There was no snow on top of the body, though, right? The body had no snow on top of it. They took a body temperature, and the body temperature was, if I recall correctly, I think it was 54 degrees. And the highest the temperature had ever reached was 38 degrees, which was indicative of that somebody had dumped the body that morning. That was the defense theory of the case, and the expert had changed his opinion on the witness stand. So that was one of the issues that came up on appeal. That wasn't reached by the appellate division because they had the issue as it relates to the search and seizure of the phone. The appellate division ruled that it was an unlawful seizure. They shouldn't have seized it for that duration. If they had believed that it contained evidence of a crime, they should have then immediately applied for a warrant. So the consequences of that, because everybody in this country is protected by the Fourth Amendment, is that the phone was suppressed. So no evidence that came as a result of the phone was able to be used in future prosecutions, and the prosecutor's office then dismissed the charges.
So is that like a case like that something where this guy's like up your ass the whole time? Like, yo, man, come on. I asked for my phone back. Like was he kind of pushing you in that direction, or was he just like did he just resign himself to, all right, this is my sentence. Like, I'm just going to like, whatever. And you guys were just fighting for him on the outside.
For the appeal?
Yeah. I mean, once he gets, tried and they say you're guilty, I mean, is he done at that point? I mean, does that take it out of him? Like the fight out of him? Or is he like, whoa, come on, I didn't do it.
I mean, still maintain he didn't do it, obviously. Yeah. I mean, he was adamant, like, from the very first time we met, that this wasn't me. I didn't do this. So we knew from the get-go, if he ended up getting convicted, there was going to be an appeal. We did file a motion to suppress the phone, and it was argued. It was ruled against us at the trial division. And then that preserved it for appeal. That's what gave the basis. Like, if we hadn't challenged the search and seizure of the phone and we hadn't argued it at the trial level, we would have had a real uphill battle at the appellate division. It would have been waived. And then ultimately, if we didn't do our jobs here at the trial division, he would have ended up with the conviction.
Just to get into it, just for the fun of it, Would the salt of your skin prevent snow from melting, or prevent snow from sticking to a body, regardless of the temperature?
Good question. I have no idea.
Okay.
I mean, their theory of the case is that she was killed in the very early morning hours, somewhere around 7 or 8 a.m., and that the body was then dumped at 9 p.m.
Mm-hmm.
Where she was for 12 hours is a question that remains unanswered if they believe that he was the one that did it.
Mm-hmm.
And then they believed that from 9 p.m. until the passerbys located her around 9 a.m., that she was just out on the side of the road, which is incongruent with all of the vehicles that had passed by. It was on Weymouth Road. You know, there's a ton of vehicles that drive by there, especially in the early morning hours. I believe it was a Friday.
You know what? It is hard to see a body, though. Like, because I've driven by, I've been on the Pike before, and like there'll be like a homeless person just sleeping on a sidewalk, and like you'll see two little feet like hanging over to, hanging over to whatever, the curb or something. And you're like, was that like a person? And most people just keep, they're just like, nah, it couldn't have been, and they just keep going. I'm not sure. Like, it would be totally noticed if there was a body just laying on the side of the road.
Yeah, I mean, maybe one person misses it or two people miss it. I think we counted there was something like 340 cars that went by. And there was a school bus that went by. And if you've ever seen a school bus, the little kids with their faces, pressed up against the windows, and the likelihood that somebody missed it for that long a period of time. Again, that was the defenses there. The body was probably placed there sometime in the early morning hours, based off of the temperature of the body and based off of, the fact.
Oh, they're saying you were saying there's no way the body could have stayed 54 degrees.
Yeah, and when we had a defense expert
overnight.
We had a defense expert that testified that body would have been placed there in the early morning hours. Yeah.
So back to like, do you have clients that resign themselves to just guilt, whether they're guilty or not, right? Whether not say like, okay, fine, I did it, but like they just don't want to fight anymore. They don't care to go to trial. They just let me do my time and get the fuck, Like, do you have that, and you guys just continue to fight this battle for them?
Yeah, I mean, certainly you have some clients that are like, all right, the evidence is just too good against me. Like, I know I'm going to get convicted. I just want you to get me the best number that you can get me. Just do whatever you can for me. Yeah, that happens all the time. You have some people that recognize that sometimes the proofs are hard to overcome. For example, somebody gets stopped by the police, right? And they've got just an unbelievable amount of drugs on their person. And there's a good reason to stop them. Maybe they had an active warrant at the time. There's no search issues. There's no seizure issues. At that point in that time, that person may be resigned to the fact that I'm going to get convicted of this, right? Like, just get me the best number that you can get me. Now, there are circumstances where somebody gets stopped and they were stopped inappropriately, and no matter what they had on them, guns, drugs, you name it, there might be a reason to suppress that stop. There might be a reason to suppress that seizure. And I'll tell them, I'll give my honest opinion. I'll say, hey, yeah, based on, there was a warrant out for your arrest, but you went to municipal court and you paid that warrant off a couple days ago. They just failed to take it out of the system. Well, here in New Jersey, we don't have what's called a good faith standard. So at the federal level, if there was a warrant that was at the time and it wasn't supposed to be active, then what the feds can do is they can operate on good faith and still, whatever they seized, that person could be prosecuted with. In New Jersey, we don't have a good faith standard, meaning if that warrant didn't actually exist, they can't be prosecuted for the narcotics that were found on them or the gun that was found on them. It would be subject to suppression.
Because they were pulling them over for the purpose of checking them for the warrant.
Correct. Okay. And if there wasn't an actual active warrant, then there was actually no basis to stop them, search them, seize them.
I mean, it is fair. Like, it's just fair. It's fair practice. You know what I mean?
Yeah.
Like there's a bunch of guys and they got guns and cars and they can go as fast as they want. They can do anything they want just about. And it's like, it's like this little game that like these like cops and robbers play, and it's like the defense part of it is it just creates that balance that's like needed,
Well, and that's the purpose, and that's what a lot of people say to me. They're like, how can you sleep at night doing what you do? Defend the people that you defend. I'm like, no defense attorney is pro-crime. Right? Like, no defense attorneys out there like rooting for criminals. Like, that's not what we do. We protect people's rights. Like, that's what we're there for. We're there to make sure you play by the rules, right? And if you have a valid reason to stop somebody and you have a valid reason to arrest them and then search them and you've dotted your I's, crossed your T's, done what you're supposed to do, then it is what it is. There's nothing that we can do. You played by the rules. You abided by the Constitution. Then the question is, what's the result going to be, right? What's the sentence going to be? And we also play a large role in that because a lot of times there's mitigation that occurs. Like not everybody gets the same sentence because there may be a reason for why they did what they did, or there may be factors. So in New Jersey, we have aggravating factors and mitigating factors. So aggravating factors take into consideration, substance use, recidivism, prior criminal history, the likelihood that they will commit another crime. There's a number of aggravating factors. Mitigating factors take into consideration the good things about people.
It's the first time he's ever done a drug.
Yeah, it's the first time he's ever been in trouble before, right? Or like if they've stole something, they've agreed to pay restitution. Or, mitigating factor 14 is they were under 26 at the time that the crime was committed. Why do we have mitigating factor 14? It's because there have been studies that recognize that younger individuals, those that are under 26, are less culpable than older individuals because studies have shown that individuals' brains don't fully develop until they're 25 years old. So if you're a juvenile and you're 17 and you're out there and you've been in trouble before and, the day you turn 18, you don't automatically say, that's it, I'm an adult now. Like I know that I'm not supposed to get in trouble anymore. Kind of doesn't work like that. And just, a day from 17 to 18, there's not an epiphany. They're still less culpable than somebody that may have been, 40 or 50 years old where the brain is fully developed and they understand the nature and consequences of what they might do. So there is a recognition that those that are under 26, and it's actually been codified, it's in a statute, it's a factor that the judges refer to. And it's a newer mitigating factor. And there's one recently that came out, mitigating factor 15, and that's for domestic violence victims. So like if somebody is a victim of domestic violence and they may have committed a crime against somebody, that factor can be considered. So for example, if let's say you have a woman that's a battered woman, right? And the husband had abused her and beat her, and she ultimately committed an offense against that person. Mitigating factor 15 could be taken into consideration that this person was a victim of domestic abuse.
She just snapped.
Yeah.
Mm-hmm. Like heat of passion, is that that's a mitigating factor?
Yeah. So heat of passion, it's a lesser culpable offense, a homicide. Mm-hmm. Normally on a murder, you're facing 30 months. Does it have to?
Does that strictly apply to murder?
No.
Or homicide?
Well, it's homicide, but yeah, heat of passion can apply to a number of different circumstances. It doesn't have to be strictly
aggravated assault or whatever.
Doesn't have to be strictly domestic.
Okay.
Yeah.
So what's the most interesting case that you've gotten to like dive into?
I don't know if I could say one, like every. You
don't have to like not to get into specifics.
Not specifics, but I would say I find most cases pretty interesting, and every day in court is interesting because there's always something that comes up. I don't know if I could narrow down like what is like the one.
You have one that like you just like thought about in bed.
I have cases that I think about all the time. I don't know if I would say they're like the most interesting cases, but
which ones are like the ones that get you to like think the most?
I would say the ones that are most challenging based on what the evidence they have. Some of the ones that I think you really think about are the ones that have a significant consequence attached to them. And you want to make sure that, because the decision's not yours, mm-hmm. whether you want to go to trial on it or not. Like you may educate your client. You may say, this is a good idea. Like I would highly suggest you taking a deal, but at the end of the day, like that's up to them if mm-hmm. they want to take it or not. But I don't think that there's one. There's a bunch of cases that come up on replay, and most of the ones are trials, right?
Well, which one? Let's get one. Let's dive in.
So I had a pretty interesting trial. And we were negotiating it back and forth. We couldn't come to an agreement on it. And the
pre-trial.
We tried
pre-trial. You're trying to reach an agreement.
We tried to reach an agreement on it pre-trial, and we were off by months, right? And we're not talking about a considerable amount of time. I mean, we were off by months, and my client didn't want to go any higher. The state didn't want to go any lower. And then when you get to that point, you got to place it on the trial list. There's nowhere you can really go on it. The problem was it was a first degree armed robbery, involved a shooting, and he had some prior convictions, so he was facing life. You know, we're talking about
facing life.
Facing life, yeah. So in New Jersey,
we didn't even kill anyone.
No.
So okay, in New Jersey, when they say life, does that mean 15 to 30?
No.
Life is life.
Life is life. Life is whatever it's based on the age expectancy at the time. No, he could qualify for parole. You know, if he got a life sentence, it would be subject to what's called the No Early Release Act, where you got to serve 85% of the sentence. But if you get an 80-year sentence, you got to serve 85%, and you're 30 or 40 years old. It's you're serving life. You're not getting paroled, right? Like you're in.
How do they call life? But how do you put a number on life?
What the age expectancy is at the time that the crime was committed. Okay. So the minimum sentence for a murder is 30 to 30, right?
Yep.
That's what we're dealing with. But for other crimes, like first-degree crimes, if you're eligible for what's called an extended term, the normal range for a first-degree crime, 10 to 20. Extended term, 10 to life. So significant consequences if you're extended, right? So this guy was facing a life sentence, first-degree robbery, serious consequences. As the defense attorney, you're always a little nervous where the fact you're fighting over, a few months, where the possibility is life, because you don't know what way a jury is going to go. You do everything that you can for the client.
What's the guy Can you understand why someone would want to fight so hard for a couple months?
Because what they wanted him to plead to specifically is not something that he wanted to plead to. In other words, the count was what he had. It wasn't the time. It was. The time had something to do with it, but it was the time plus the count. So it was a two-factor consideration, and he didn't want to go a day above of what because his position was, and I think it was the right position, that the story that the victim was telling was a lie. Like it totally did not go down that way. And I think the physical evidence in the case showed it, and it ended up working out for him. So we tried the case, and the cross-examination of the victim probably went as well as it possibly could have. I mean, he told 3 different versions of the same story. He was all over the place. And then the physical evidence. The physical evidence was what really did him in. So I'll just give you a little overview of it. So basically, the allegation was, on one of the stories, that my guy had taken out a gun, had demanded his money. When he told him he wouldn't give him his money, he shot him in the foot, and then he fell back into the room, and then he shot him again in the foot, walked over to him, took his money, and left. Right? That's the general gist of what he's saying has happened. Again, it was a bunch of different versions that were told, but that's the general story, right? The physical evidence showed something different, though. So if you looked at it, the gunshot wound that he had to his left foot went directly down at the top of the foot and out the left pinky toe, indicating that the gun was fired in a direction away from the body. And then the second gunshot wound was down through the back of his Achilles, down away from the body. So if somebody had shot you from across the room, there is no way that the direction of the bullet could go from the top of your foot out the pinky toe. He was holding the gun at the time that this happened. Like, make no mistake about it. The shell casings that were found weren't found right here where the gunshots were fired. He had alleged that the gunshot was fired from a doorway. If that was the case, they would have been ejected and fired behind him. There was a ballistics expert that the state called and ended up helping in the defense. The gunshot, the casing was actually found right next to the alleged victim, right by the back door, which further supported that he had the gun at the time.
So he shot himself in the foot?
So there was some kind of tussle, right? I don't know what occurred. There was some kind of tussle over the gun, but what's pretty clear is that the time that the gun went off, the gun was in his hand. So he testified. The jury didn't obviously believe what he said. They came back and found him not guilty in 15 minutes. Probably the quickest verdict that I've had. It was a 15-minute not guilty verdict.
And that's a big one too, man.
It's a big not guilty verdict. I mean, he was over the moon. I mean, he immediately broke down crying and gave me a hug.
Yeah.
I can't imagine the emotion that he was experiencing at that time, looking for the possibility of facing the rest of your life in state prison to, walking out the door. So that's one that I think about. That's one I think about often because it's like, you never know.
What was the plea?
I think the plea they'd offered 5 must serve 5
years.
And and he wanted a 5 at 85, I believe. Five must serve 85, something around there. So we were off a little bit
Right
on that.
there,
Or
yeah.
like 5 to 3.5. It was whatever it was. We weren't off by a whole lot.
So he went from he went from like 5 years to life to zero.
Exactly. Right. Yeah.
And then what happened? So like he's being held in prison the whole time, right?
He's being held in Atlanta County Jail, just waiting.
Do they have to pay everyone when there's a, what do they do? Nothing.
No.
They just let you go and that's it.
Yeah. Because the whole question is, there's probable cause at the time, right? A grand jury indicts them. Are there cases where somebody could file a malicious prosecution? Sure. They could talk to a civil attorney about that. I don't handle that.
Okay.
My whole realm is criminal defense. It's the only thing that I do. That's the only thing that I've ever done. I was a prosecutor before I was a defense attorney, so I kind of got to see it from that angle. And even then, criminal law is the only thing that I did.
Why'd you switch?
I did defense work before I was a prosecutor. I was in private practice for a little bit. I did pool work. For someone else, you were a clerk or something? Yeah, so I'd worked for a local attorney for about a year, and then I was out on my own for a little bit. And honestly, when I was in law school, I had interned at the prosecutor's office. I ended up making friends at the prosecutor's office. I really liked working there. I was down in Cape May County. And then I made a decision. I was like, all right, whenever a spot opens up, I want to go to the prosecutor's office because my whole goal was I want to try cases. I want to try as many cases as I can as quickly as I can. And the prosecutor's office and the public defender's office are the two places that you can try the most cases. Like you have a larger volume of cases, and therefore it gives you the opportunity to try more cases. So
why is that like such a big goal?
Try cases? You learn the value of a case. You learn how to question witnesses, whether it's on direct, whether it's on cross-examination. You get in front of a jury. You get comfortable. You get comfortable speaking. You know the intricacies. You have more emotions. So the way that I explain it is it's kind of like getting in repetitions, right? If you're in private practice, some people that work for a firm may never see the inside of a courtroom. Or you may go and you may be there sporadically. The odds of you trying a case aren't always that high. If you're at the prosecutor's office and you have, 200 active files, high probability that one of those cases is going to go to trial. Same thing for the public defender's office. You have 200 or 300 active files. High probability that one of those cases is going to get tried. Because you have a larger volume of cases, the higher likelihood that you're going to have motion practice and you're going to have trials. So that was always my goal. I mean, the reason that I went to law school was to become a trial attorney. I'd had no idea at the time whether I was going to do civil law or criminal law. In fact, I thought originally I would like to do, civil law. It wasn't until I got to the prosecutor's office and interned there that I was like, I actually really enjoyed this. I think the case is interesting. I like criminal law. Like every day in court was a new adventure. So I think criminal law is the most fun.
So you go from the prosecutor's office, you have friends in there.
Yeah.
And then how did you make the decision to?
So it sounds crazy, right? But like years ago, probably over, 10, 12, 13 years ago, I had wrote down, spend 5 years at the prosecutor's office, try as many cases as I could. Spend 5 years at the public defender's office, try as many cases as I could, and then go out into private practice, right? Things change because I ended up loving the public defender's office. Like we have a great office. I have a lot of fun with what we do, and I'm enjoying being there. So the reason that I went prosecutor's office and public defender's office because I wanted to see both sides of how to attack a case, right? Like you learn the intricacies of the case. If you are a prosecutor, you learn what prosecutors are thinking. You learn what you need to prove a case. You learn how to handle direct testimony. You don't get a lot of experience with handling cross-examination because usually you're the one that's presenting the case. And on the defense side, it's the complete opposite. You usually don't handle any direct unless you're calling witnesses. Usually what you're handling is cross-examination. That's the most fun. I think the cross-examination is probably the most fun thing that you do. I look forward to that, whether it's in motion practice or whether it's in trial practice.
What makes it so fun?
It's getting to be, well, in juries, it's fun because you're in a courtroom full of people. It's I don't want to say it's putting on a show, but it's, you're in front of you're putting on a show. It's part theater. You're presenting your opening statements, you're presenting cross-examination, you're doing your closing statements. So that's what it is. I think it's just fun in terms of the questioning of witnesses too. And, I've been known, I prepare thoroughly for cross-examination. And usually when I'm asking a question, I know the answer to the question.
We're supposed to, right?
Supposed to. And I know where I need to go if somebody says that the answer is different than what I know it to be. I have the materials that I need to impeach them on it. So if I'm asking a question, I already know the answer to the question.
So do you pick things up from the original round of questioning? Is that, or like, is it like the movies where, like, you know, the prosecution comes in, they ask questions, then you immediately come in and ask questions right after?
Yep.
Or do you get like time to?
No time.
Okay. So how do you know what the prosecution's going to ask? Or this is just independent research you have to basically kind of figure on? So
honestly, to me, 90% of the time, it doesn't matter what the prosecutor asks. It doesn't matter what
you
they
just
say.
Want to get what you're going to get.
I have my own story that I want to present, and I want to present it through the witness, and that's what I do. You know, I tell my client's version through the witness, and that's what I think cross-examination's for. Cross-examination is there to get your theory of the case out.
How can you know the answer to the questions?
Because likely there's been a police report if it's a police witness. Okay. If it's a witness that is testifying.
Like, and you were driving home that night?
Yeah,
like, no, I didn't drive home that night.
Or if it's just a lay witness, like somebody that observed the crime, they took a statement from them. I know what they said in the statement. So going back to that one case where we were arguing over a few months and it went to trial, this guy gave 3 different statements. And 3 different statements gave 3 different versions of events. So I already had those statements prepared. So when I asked him a question and he said, I didn't say that, you have the statement, you walk it over, you impeach him with it.
Right.
And then you ask him again, you know, you testified to this. I didn't say that. Walk over. You grab the statement. I make a point, and I have a book. I put the book all the way across on the other side of the courtroom. Ask him a question. I didn't say that. I walk all the way across the courtroom. I get the book and bring it back. I impeach him on it. Walk back, put the book down. Ask him a question again. And kind of at some point, it becomes like a dog with the newspaper. You know, smack, 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 smack. And eventually they say,
stop lying.
Yeah. Eventually they say, listen, if that's what you said, okay. That's what I said. So that's the purpose of cross-examinations, to get your story out and ultimately to control the witness.
Man, that does sound fun.
It is fun. It's a lot of it's so much fun that, like, at the public defender's office, they have probably one of the best training programs for new attorneys, and they make everybody go through it. Like, you have to go through the training program at the public defender's office, no matter how long you've practiced, no matter what you've done. You know, they put people in my office that are very experienced through it. I got to the public defender's office. I was a certified criminal trial attorney, which there's only, I think it's less than 1% of the attorneys in New Jersey are certified by the Supreme Court as a criminal trial attorney. I was one of them, and they still made me go through it. And I ended up enjoying it. I said, this is great. How can I be a part of it? And I volunteered immediately, and I've been doing it ever since. You know, they put on a couple different programs of the year. They train all the new attorneys, and we train them on everything. Opening statements, closing statements, direct testimony, cross-examination, theories of the case, you name it. You get one of the most comprehensive training programs if you join the public defender's office. So it's great. I love being a part of it. It's one of the things that I volunteer for. It's one of the things I look forward to the most. I probably go up to Trenton at least 3 or 4 times a year to help out with the programs.
Cool.
Yeah.
That's awesome. So how long were you prosecuted for?
Well, over 5 years.
And how long have you been a defense attorney for?
Oh, how long have I been at the public defender's office for?
Yeah.
So at the public defender's office, I've been there got there in 2000, going on, it'll be 7 years this summer.
You got your list, right?
Yeah,
5 years, 5 years?
I'm over it. But yeah, I enjoy it. It's a lot of fun.
Are you, do you have in the back of your mind going private?
I've always had that, but, you know, it could be 10, 15, 20 years from now, you know?
What's like the benefit of going? Like, why would someone decide to, is it just money?
I think it depends on the person, right? Like, for some people, it might just be financial. They might just say, hey, you know, I want to go out in private practice. I want to make more money. For other people, they may want to have just their name on the firm. You know, they might want to sponsor a little league team and have whatever their firm name is on it, because that's what they want to do. They want to have their own firm. They want to have their own thing. Some people just want to be their own boss. You know, if they want to come into the office at 12 o'clock in the afternoon, they come in at 12 o'clock in the afternoon. If they're one of the people that say, I like to work, you know, from 7 p.m. until 2 a.m., you know, then private practice is probably for you. You know, you're not going to be at the prosecutor's office saying, "Hey, I'm not going to."
You can't do that.
Or the public defender's office. No, you're like, if you're at the prosecutor's office, the public defender's office, you're typical
9 to
government.
5,
It's 9 to 5, yeah. Now, if you're in trial, it's 9 to 5 plus you got to prepare for trial. So, like, yeah, when you clock out 5, you go home. You're still probably up until 10, 11, 12.
You're not preparing for trial during your 9 to 5 while you're 9 to 5 thing?
No, because you're in trial.
Wow.
You know what I mean? Like if you're in trial during the day, you're obviously not preparing for the next day's testimony because you're sitting there, you're in it, like you're doing it. So like you got to finish, you got to go home, you got to eat, and then you got to immediately get
turnaround.
cracking.
It's a 1-day turnaround.
There's no breaks. So you do openings. So a lot of times, what I've done is I've picked a jury in the morning. That afternoon, we open. We might get to the first witness. The next day, we come in, we go straight through witnesses. The next day we come in, we go straight through witnesses.
And none of this is prepared until the night before?
No. You have it generally prepared, but you still have to get ready for the next day. You still have to refresh what questions you're going to be asking. You don't always know what witnesses are going to be called in what order. So like you're still getting ready for it.
And are you alone or you have like a team?
So we have investigators that work for our office. So we might have them, but typically most attorneys are trying the case on their own. Now, what I do is I'm in a position now where I can help some of the younger attorneys. So like if a younger attorney has a trial, I'll obviously help them with the case. I may even sit second chair on it if there is anything that comes up or any questions that they have, just to basically provide whatever support that I can. But for the most part, most people are trying the cases and they're trying them on their own. Unless you're dealing with some really complex litigation, trials are usually not a team sport. You know, it's a one-person event. Unless you're dealing with some really complicated issues, in which case you may have another attorney that sits with you. Yeah, but usually it's just them. And honestly, the older I get and the more cases I try, I love the 1-week trials. They're the best, right? You get in, you handle the case, you get it done with, you can move on to the next one. Ones that are tough are the ones that go on longer than that.
What's the longest?
Longest trial that I've ever personally been involved in, 6 weeks. And it's a lot. You know, it's a lot.
It's every day for 6 weeks?
Yeah.
How long was like the OJ trial?
Months.
Months?
Yeah. And there's some trials, like especially like complicated, and I don't do any federal stuff, but especially like complicated federal things, like they go on for several months. Yeah. Like real, and then like complicated RICO cases go on forever too. Yeah. There was actually, there was a case down in Georgia. I'm trying to remember. He was a rapper. I'm trying to remember what his name was, but his attorney was Brian Steele. I don't know. Did you ever see any of the clips from this?
Maybe, if you keep going.
So it was a trial. It was a large like racketeering case. It went on for several months. And Brian Steele he's a fantastic defense attorney. He's a great defense attorney. And he gets wind that there was a witness that was in the judge's chambers, and basically, I guess, provided a proffer. The defense wasn't made aware of it. So on the record, he asked for a copy of the transcript, and he asked, you know, what occurred, like what was said. And the judge's question was, well, tell me how you find out about this. He said, well, I'm not going to do that. Did it occur? And if so, I want a transcript of it. There shouldn't have been an ex parte conversation without me being present. And the judge said, well, if you don't tell me, I'm going to hold you in contempt. I'm going to throw you in jail. And he said, well, Judge, I'm not going to tell you. So listen, I'm going to give you 5 minutes for you to go think about it. He goes, I don't need 5 minutes. I'm not telling you. And he said, well, that's it. You're in contempt. You know, I'm sentencing you, you know, to be incarcerated until this trial is over. And he walks up to the podium and he goes, Judge, I just have one request. Could you put me in the same cell as my client so we could work on the case while we're in there? And it was like the biggest boss move that I've ever seen. If I remember the name of the client that was representing, I'll reach out to you. I'll let you know. But it was crazy. But yeah, some of those cases go on for months.
They can hold them in contempt for that?
No. I mean, there was an order that came out. They challenged it. And he didn't end up spending any time in jail.
What is that? Because like I've seen that in my cousin Vinny, right? Where they can hold you in,
they can hold you in contempt of court. You know, it's not something that's used often.
What's that mean now?
What does
contempt of court mean for an attorney?
So, I mean, it applies to anybody, and it's basically interfering with the court's proceedings, right? So somebody can get held in contempt if they're yelling and screaming in the courtroom and they're, you know, interfering with the judge's ability to conduct the affairs.
And then they go to jail.
judge can hold a contempt proceeding, and the judge can ultimately sentence them to, up to 6 months in jail.
Really?
Mm-hmm. Yeah. Yeah. I mean,
You wonder why, like, how
it doesn't happen
Joe
often.
Pesci. How did Joe Pesci get out every day?
So he made him pay. Right? Like, he made him pay. That's a great movie, by the way.
Yeah, it is.
And it's one of those movies, like, when I'm scrolling through and I'm flipping channels and I see it, I stop and I pause and I watch it every time. It doesn't matter what part of the movie that it's on, And I tell all the younger attorneys, I'm like, you gotta watch it. It's just such a classic.
That's one same for me. Forrest Gump.
Yeah.
Another one. Don't matter where it's at. I don't care if it's like 5 minutes left. I'll watch it.
Yeah.
I don't care.
Yeah. Some of those movies.
Yeah.
But the big one, that's probably one of the biggest ones for me. I can't even tell you how many times I've seen it.
I've seen it quite a bit. It's a great movie.
It's awesome. And it's like it's not real in terms of what occurs in the courtroom, but like some of the things that he does in there, like, yes, defense attorneys would use. Like, for example, knowing the answers to questions beforehand. When he's talking to the guy that says, I was looking out my window, I was cooking my grits, and I looked over and I saw this boy, shoot them.
Yeah.
And he says, did you use instant grits?
Yeah.
And he said, no, self-respecting Southerner would use instant grits. Yeah. And he said, well, you boiled your water, and then he gets into like how long it takes the water to boil, because everybody knows that
the laws of physics cease to exist on your stove.
Exactly, right? Like that's having the goods. That's knowing what to do with it, right? Like that's a good cross-examination, right?
Yeah.
And it comes from a movie, and it's pretty funny. And a lot of times in trainings, like there's clips that are used from that movie.
No kidding.
Oh yeah,
that's awesome.
Yeah,
that's really cool. So. How would you go, like, say you were to go private, right? Mm-hmm. How would you confidently do that, right? How does an attorney go from working 9 to 5, guaranteed paycheck, guaranteed clients, guaranteed action?
Yeah.
And then you're just stepping into like the abyss, right?
You're 100% stepping off into the abyss.
How do you know that phone's going to ring?
You don't. No, like that's the thing. You don't know.
Can you start while you are in the public defender's office?
No, nobody, like if you're in the prosecutor's office, the public defender's office, like you are completely limited to what you do.
You're not allowed.
No, you're not allowed.
Okay.
Like you handle all cases as a prosecutor, you handle cases as a public defender, there's no in between. Now, what a lot of people do, and it's a good cushion for most people, is they handle all cases as a pool attorney for the public defender's office. So our office doesn't handle like conflict cases. For example, if there's co-defendants and those co-defendants have a defense that is incompatible with each other, obviously it wouldn't be appropriate for two people in my office to handle the case, right? Because there's a conflict with the office. So we have to pull that file out. And what that does is it goes to a pool of attorneys and it gets assigned to those attorneys. Now,
does it go out like for bid?
No. So you're on a list, right?
And just one, whoever's next.
And it just rotates around on the list. And honestly, I mean, for somebody that is at the prosecutor's office and has a couple years of experience, maybe you've been doing it for 2 or 3 years, you've tried a couple cases, you've gotten your feet wet, and you decide you want to go into private practice, getting on the pool list is probably the best thing that you can do. The rates have increased over the years. Now they pay them $100 an hour. They can bill up to 1,500 hours a year. So you can bill $150,000 just as a pool attorney. Mm-hmm. So like that serves as a pretty good cushion, especially for somebody that's working at the prosecutor's office.
Can you be a pool attorney from multiple counties?
Yeah.
So you could do Cape May County, Atlantic County.
Yeah, the 1,500 hours still is the cap total.
For all of them.
For all of them, but you can go.
Just so you're busy.
Yeah, you can go to whatever county you like. And that's what a lot of attorneys do. Like if they decide to make the jump into private practice, they'll get on the pool list. They might take pool cases, in Atlantic or Cumberland or Cape May. And as they start to do it, they are seeing more clients, see them in action. They see how they are interacting with their clients, the prosecutors, with the judge. They may say, I like this guy. He's done a really good job. Like, can I get your card? I'll hire you. So I would say that the pool list provides a pretty good safety net for most people. And again, if you're a prosecutor and you've been there for a little while, it's not a bad idea to, if you want to build your own firm, to get on the pool list as soon as you leave.
So would the other option be to go work for someone who already has a private practice established?
You could absolutely go.
And they just put your name on the thing,
Well, no, you could go work for another firm. The only downside of that is you're trading one job for another job. And likely when you're working for a firm, you're not working the normal 9 to 5.
Mhm.
You're not getting all holidays off.
Right.
You're probably working 40, 50, 60, 70 hours a week, depending on what firm you work for. Now, if your sole interest is, I want to have a stable job and I want to have a stable paycheck and I want it to be more than what I'm making, then, maybe the firm's for you if you decide that you're fine with working, 60 or 70 hours a week. And that's a judgment call by you.
Mhm.
Yeah. And some people say, I want the safety and security. I want the guaranteed paycheck. I don't want to have to worry about billing these pool cases and then get paid out whenever the case is over.
How long is it going to be till AI can just do your job?
Well, here's the scary thing. For attorneys, it's going to be a really long time. I don't know if it's going to.
You think so?
I don't think it's ever going to replace an attorney. Paralegals are in trouble, though, unfortunately. Right? Like, the advancements of AI have gotten so unbelievable, and there's still
find anything you want.
Still more to come, right?
Oh, I need case files. Boom, here you go.
So, like, Westlaw right now has Westlaw AI, and they have what's called co-counsel, and I'm playing around with it and the features of it. Like, again, what I said with the public defender's office.
Westlaw is like an AI software for
Westlaw
attorneys.
Is a legal search engine,
Okay.
right? And there's been like advancements on Westlaw where they now have like an AI version of it. And the public defender's office, they have been great in terms of identifying and seeing the future of AI and getting us on board with it, right? Like, we had an AI training. I participated as a panelist to help educate attorneys on AI, just to show like things that AI is capable of doing. And I'll get into like some of those things, but just talking about Westlaw, like, you can ask just a general question, just a basic question, like, if somebody, let's say if somebody had an expungement previously and they got convicted of a new disorderly persons offense, are they eligible for another expungement? Usually you couldn't just ask a general question like that. That's a question you would ask a paralegal, and the paralegal would spend hours researching it and type up a memo and generate it, right? Westlaw AI can give me that answer with a full memo generated in less than 5 minutes. And I mean, like, really comprehensive. Pull me to every single statute, all of the case laws, give me a summary. If I decide I want to turn it into, like, let's say I ask a legal question and I want to turn it into a letter memorandum. Sure, write me a brief, right? It's so advanced that you could take a brief from an opposing party, upload the brief, and say, generate a response brief to this brief.
Yeah.
That's how advanced that it's gone.
That's what I'm saying. Like, you guys are fighting, like, you could, like, if you had a really good attorney who's very, like, hip with the artificial intelligence and two of them against each other, like, you could basically just have, like, a robot war in court.
Yeah, I mean,
you're just like the vehicle for this robot.
You're the vehicle, because at the end of the day, you're still the vehicle. It's got to be put forth. You got to argue, and you also got to make sure that you double check everything. Like with Westlaw, it's closed loop, so you shouldn't hopefully have an answer. There's been some attorneys that have gotten in trouble using ChatGPT because they've had it write briefs for them, and the attorneys have submitted the briefs and they haven't checked any of the sources. And then it turns out it's completely hallucinated a case. It's made up a case that doesn't even exist, and they've submitted it to the judge, and the judge
Isn't that weird how it does that sometimes?
It does.
Why does it do that?
It'll just make something up.
It does that to me and Lou too.
Yeah. It'll just make it up completely.
That's not true.
Right? It'll just completely hallucinate it.
Look, I was it has like these avatar things, so I was messing around with it, and I was trying to make me and the baby on like a cartoon, or it was something, right? It was a caricature of me and the baby, and it's like and it was just like me in like a firefighter like outfit, and I was like, I'm not a firefighter.
Yeah. Where'd you get that information from?
ChatGPT knows a lot about me.
Oh, it does.
Way more than
it pulls all public sources. Like it
knows everything about the podcast. Yeah, knows everything about like campaign for school board. It knows everything about. I mean, I pulled so much data out of like I put data into it to pull stuff out,
and it's only gonna get
so I could like get a target. Yeah. So like it knows all these things about me. It knows my diet. It knows what I everything. And then I'm like, do this caricature, and it's like me in a firefighter costume. I'm like, look at that.
AI is becoming so unbelievably advanced, right? And like
we're feeding it.
Yeah, and we use it to our benefit. Like for New Jersey State employees, there's actually a closed AI program that we have access to that it's not a learning-based model. So basically, it's not storing any of your data. It's secure end to end. So if you're asking it a question, or like one of the things that I think it's helpful for is if you're maybe taking like emails or letters that were written by, you know, a secretary, a paralegal, a client, a character letter, and putting it in there and just correcting grammar and speller. It's very good at correcting grammar and spelling. Like AI is probably the best proofreader you'll ever have if that's the only thing that you're going to use it for, right? And like some of the other features of AI are becoming really advanced. Like the deputy in our county went to an AI training yesterday, and we were talking about it today, that there's a new technology with AI where it can take 1 minute of your voice, 1 minute of your voice, and it could then generate anything that you want it to say.
In any language.
It clones your...
In any language.
Yeah, it clones your voice.
Yeah.
So like the scary thing is like somebody gets into a fight with their significant other and, you know, they call and they have AI generate a threatening comment or a threatening statement that never actually came from that person, and then they file charges saying this person threatened me.
Well, you need AI to listen.
Yeah.
And you need AI to be able to detect itself.
How can you detect it, right? Like that's the question.
You need artificial intelligence to be able to. There's got to be something. There's got to be something in there that's detectable by the source itself, you know? Now, you hear these stories about how artificial intelligence doesn't want to like oust itself, right? So like it'll write itself messages to like preserve itself like down the road because it sees like this new, you know, this new, reboot of itself is coming. It's going to wipe itself out. Like point one or gets wiped out by point two, and it tries to save itself. You know, you hear about those kind of stories, but like, how long is it going to be till you just, you know, you have someone doesn't want to pay an attorney, doesn't want the public defender, doesn't want none of that, just records a conversation on his phone. Let's Westlaw listen to it. Westlaw transcribes it, summarizes it, and then gives them a defense.
Oh yeah, I mean,
it can't be that long before that could happen.
No, but right now, I mean, and like everybody can do that. Like you and most clients.
But isn't that comprehensive? Isn't that a comprehensive?
Yes and no. I mean, a lot of it comes into the intricacies of it. Like you are able to identify things just based on experience and based on tendencies in counties that AI may not know, right? Like they may not know, you know, in terms of what negotiations may be like with this particular prosecutor or what sentences may occur with this particular judge. They may not know nuances in terms of like certain counties. Like you could be down in Cape May County and, you know, you're getting state prison for a bicycle theft, where you're up in Atlantic County and, you know, you're getting a suspended sentence or like fines and penalties. Right. Like there's a difference in sentencing. If you rely solely on AI, it depends on what county you are, you might end up getting some bad advice from AI that may result in you spending some time in, you know, the county jail or state prison. Yeah. So that's one of the things you got to be careful about. And then AI is not going to be doing opening statements. They're not going to be doing, you know, direct examination and cross-examination.
It just cuts and paste like my cousin Vinny.
Yeah, nobody wants to listen to a robot or algorithm or, you know, hologram talk, right? They want a real life person. They're there for the show.
It's a ways away. It's a ways away.
But it will replace a lot of jobs. Yeah. Like, I mean, it is
all that data stuff.
Yeah, and think about it just like with secretaries, right? Like there's Smith.ai that's now an answering service. It's an AI based answering service that somebody could pay, you know, $200, $300, $400, $500 a month and have this answering service that is an AI answering service that somebody that calls in may not know it's AI. You know, it's becoming so advanced with AI that they can have a conversation with a person.
I have a robot answer the phone for me. Yeah, and just because spam's crazy.
Yeah, and some of the advanced models are becoming so good that like nobody can tell. And it's replacing jobs of like administrative staff. Like it's replacing jobs of secretaries, because if you could pay a you know, Smith.ai or one of these services $200 or $300 instead of paying a secretary a few $1,000 a month. I wonder if you would
like upload all of the you know, problem solving stuff that you would need like for that particular secretary, you know.
Oh, you can.
Yeah, but how?
You can train models, right? Like you could build an avatar based on whatever you want. You're you know, say you're in private practice and you have an answering script for like an intake for what questions you want asked of certain people that come in. Like you can train a model based on that. And they have like Smith.ai is one of them. There's like a bunch of different ones that you can use. I was
on the phone with a secretary today. I wonder if I got bamboozled. It sounded like an older woman, but like she like laughed. Like it was a very human conversation.
Isn't that
But
the
like
best?
now that I'm
Think about
thinking
it, like,
back,
but who would suspect like an older woman, right? Like nobody's like this
I
older
know.
woman's not.
This conversation's
not gonna
making me
use
think.
AI,
I got.
right?
I know.
Like it could very well could have been,
It could have
right?
been.
Who's suspecting of a little old lady?
You know who she reminded me of was you ever see Sing?
Who?
Sing. You have little kids. Sing.
No,
Oh, dude, it's like the animated show.
we haven't gotten to that yet.
Matthew McConaughey is like the little chipmunk guy or something. But there's like this old lizard lady. She has like a fake glass eye, and a glass eye always falls out. But it reminded me of the voice. Reminded me of her.
Eventually, we'll get to that. We've been stuck on like Coco and Despicable Me. And
you gotta get to Sing.
We'll eventually get there. I'm sure.
2-year-old would love it.
Yeah.
Songs. It's all good songs.
I like songs. That's why he likes Coco.
Yeah.
He was obsessed with it.
It's elephants and stuff.
Perfect.
Koala bears.
Sounds like a good movie.
It's pretty. It's not bad.
The only thing is, once I introduce it to him, I'm gonna have to watch it like
it's fine.
40 times
It's
in a
fine.
row.
That's not a bad one.
Just like Coco.
K-pop Demon Hunters.
I don't know what that is.
It might be one of the best kid shows in the world.
Really?
So I'm watching a reel or something on my phone, and this song is like in the background of the reel, and it's a song from the movie K-pop Demon Hunters. I don't know nothing about K-pop Demon Hunters at this point. My 4-year-old daughter is singing this song that's on this reel, and I'm like, how do you know this song? She's like, that's Golden. I'm like, what is Golden from? She goes, oh, we listened to it in class. I'm like, what is it from? Oh, it's from K-pop Demon Hunters. I'm like, K-pop Demon Hunters. So then I go in the remote. I'm like, K-pop Demon Hunters. And it's like this, like this claymation, like really good graphic, like Asian kind of, I don't know,
an anime type
like
thing?
an anime type thing. Yeah. I don't know if that was the right word for it, but yeah, it is like an anime type thing. And it's about like, just like these like group, like this boy band and this girl band. And they're like, one's demons and one's demon hunters and it's whatever. But these songs are amazing, dude.
Haven't gotten
like
there
we
yet.
jam out, bro, in the car. It's awesome.
Yeah, haven't gotten there. He's been on, you ever watch Bad Guys? He's been on to Bad Guys lately. Bad Guys 1, Bad Guys 2. Yeah, it's pretty good.
It's cool.
Yeah.
You're done with like Blippi and stuff? Miss Rachel?
He loves Rachel.
Bro, I almost like had a meltdown because I couldn't listen to Miss Rachel for one more second.
Yeah.
I like I literally had to take the baby and like leave the house.
There's the 2-year-old and we have the 6-month-old. So like now the 6-month-old's obsessed with Rachel, right? So, and the 2-year-old he's still kind of into it. But Rachel plays a lot of it.
But well, I have like an 85-inch TV and it's in front of the living room in the middle of my house and there's no blinds. There's no blinds. So people will drive by my house and they can see Miss Rachel on the TV and they're like, yeah, we watch Miss Rachel.
It always is playing in this house.
It's always. Always.
Kids
it's just on loop. Miss Rachel. Just put it in, put it in.
Over and over again. Hi there, right? and it's funny because like it'll come on, the 6-month-old will be like,
yeah. No, they stop what they're doing. Yeah. Stop what they're doing.
Yeah.
It's great. It's kind of great. It's kind of bad.
Yeah.
Can't tell if it's bad or good yet.
I had a friend that like saw it for the first time. He was like, this is like crack for them. He's like, if this existed when my kids were around, I would have just sat them in front of the TV for hours and just played it.
It is. Like the Coco Melon.
We haven't done any Coco Melon. No, we're going to avoid that.
It's like songs that just are just.
I've
they
seen
just
it.
never end.
Like we're not getting into the Coco Melon. Yeah.
Coco Melon's no good. I don't like that show.
No, we try to avoid that.
Good call, dude. So what else, man? What else have you been doing? Anything good?
No.
CrossFit? Done with CrossFit?
No, I haven't done CrossFit in a while. Waking up at 5 o'clock before kids was a lot easier.
Yeah.
Waking up at 5 o'clock now, not easy.
You can't sleep.
You can't sleep. I think that last night was the first full night of sleep that we got, like uninterrupted by either kid, probably since Jack was born, right? Probably since the 6-month-old was born. And then we thought we were getting to that point, and then the 2-year-old, the day after his birthday, decided to climb out of the crib. Like the very, very first time that he even tried it, he was just like, whoop, I'm out. And then proceeded to destroy his room for an hour and a half.
Yeah, and that's a new trick, so they want to do it all the time.
I was like, he's getting in the toddler bed tonight. He's going to end up breaking his neck. So like now nap time is like an hour and a half of him just totally destroying his room. just like the Tasmanian devil, just pulling things off the bookshelf.
Yeah.
He's taking clothes out of the dresser drawers, and eventually like he passes out. And the first day that he climbed out of the crib, after Tasmanian the devil in the room for like an hour and a half, he passed out. He passed out right in front of the door with his tiny little fingers, like hanging out of the door. So we're like, all right, at least he's out. And then we put him in the toddler bed, and it was experience the first time we tried to get him to go down. And then he eventually crashed. And then the same thing last night, you know, it was a meltdown trying to put him in the toddler bed, and then eventually he crashed. So we're gonna hope for some good sleep tonight. But
what an adventure all the time. Were you saying you went somewhere recently?
Yeah, we went to Disney, and
was that the first time?
The first time. It was the first time we've ever been down there. It was an experience.
Be honest. Was it horrible?
Well,
it was miserable.
It was an experience.
It was miserable.
Well, listen to this.
You fucking lawyer, dude. It was miserable.
Here's why I'm going to tell you it was an experience, right? So my 2-year-old is like shot out of a cannon.
Mm-hmm.
Like this kid is ready to go at all times. And my wife and I were like, man, he's like clingy and mopey today. Like, and that's just not him at all. It was the first day we got to Disney. We're like, maybe he's just tired from the plane ride. And, yeah, all out of him. And then that night he spiked the fever. It was like 103 fever. And of course, you know, we're staying right by Universal, and there's no hospital or urgent care for like 30 minutes away. We're like, what do we do? So we call the hotel, and they're like, oh, there's a concierge medical service. Of course, not cheap.
Mm-hmm.
Like, whatever, better than spending the entire night in the ER. Come here, evaluate him. He's got a double ear infection. Right? Same thing happens to the 6-month-old.
A concierge medical service?
Mm-hmm.
Wow.
Yeah. They come to your hotel room.
And you got to pay out of pocket?
Got to pay out of pocket.
Oof.
Yeah, not fun. Right? So.
God damn it. Disney, they charge you $25 for a frozen pizza.
No, I know.
I can imagine what a medical professional costs.
Yeah. Yeah.
Holy cow.
And then, you know, the 6-month-old ear infection too, right? And then we're just like.
In Disney? Both of them?
Both of them. Yeah, and then we're just run down, right? Like we haven't slept. The two of them have been alternating being up all night, and we're like, oh my God, this is miserable, right? Like we paid all this money to be here, and everybody's sick. And then I was like, I feel like I could pass out right now. I've got like this terrible headache. I feel awful, and we're thinking maybe it's just because we haven't slept, right? and then Megan's mom wakes up and she's down for the count, and Megan's not feeling well, and we're like, oh my God. What is going on right now? And then the day we're going to leave, her sister wakes up. She's down for the count. Her niece wakes up. She's down for the count. We're like, everybody's dropping like flies, right? So the day after we get back, they take her niece to urgent care. She tests positive for the flu. So we think it's probably the flu that everybody had, and it was.
And you did nothing fun.
Oh no, we didn't. We still did everything. We just sucked it up because we just thought we were like.
The kids were okay.
Kids were fine.
Yeah,
like they had, you know, they had their prescription. They were on antibiotics. Yeah. They had Tylenol, so like they rallied, and then we were like, you know what, we're probably just being wusses.
Weather was probably not bad.
Yeah, it was like when we first got there, I think it was like low 60s, and by the time we left, it was like 80. Yeah, it was fine. Bad, yeah, and we were like, oh, we're just, you know, we're getting older. We just haven't slept. We're probably just really tired, you know.
That's brutal, dude.
And then come to find out that there's like a 95% chance that we had the flu, and it just worked its way through. But we did everything, you know. We went to Universal.
Just passed it right around the whole.
We just super spread it. No, unknowing, but it was just super spreading around Universal and
allegedly.
But 2-year-old had a blast. I mean, Michael was like all about. He likes anything that goes fast. So like we put him in, you know, the teacups and just spin it hard as you can, and as soon as it finishes, he's like all dizzy, and he's like, more. And we're like, all right, we'll go back on it. And then we were right by the Hulk ride. I don't know if you've ever gone on the Hulk at Universal.
I've never been to Universal.
No, Universal's bad. I highly suggest going there. Like, next time you go there, like go to Universal. And Disney was fun. The kids liked it, but Universal's way better. They've got roller coasters, and a whole bunch of different rides, but like the Hulk, like shoots like straight out, and it goes right into a loop, and he looks up into it, and he's like, that.
No way.
You are not.
He's big enough?
No. No, of course not. But if they let him on it, he'd walk right up to the front of the line and go on it. Like the kid's not afraid of anything. He's like, that. Like maybe in a few years. You can't go on the roller coasters.
You know, like the little roller coaster they had at the Hammonton Carnival? Dude, my son was like losing it the whole day. He's like, get me over here.
Really?
Like, bro, really? Yeah. He's with his boys.
No,
I could see him just like crying the whole time. Like, come on, man.
Michael is built for speed.
Yeah, cool.
Speed. And like sometimes we took
him.
Ain't
first, last.
Yeah, we took him to the boardwalk over the summer. We went on some of the rides there, and like the first ride, we were like whipping around, and Megan was like, I don't know if he's gonna be like sick or he's gonna like pass out. And he finishes it, and he just looks at me and goes, more. I'm like, more. All right, we'll go on it again, buddy. And then it was like a fight to get him off the ride after the second time. We're like, there's so many more rides to go on. But now he was like, let's go.
That's great.
Built for speed.
That's great.
Yeah, man.
Cool. Dude, thank you so much for coming down.
Yeah, absolutely.
Hanging out.
Yeah,
telling us about being a public defender?
Yeah.
That's so interesting, man.
It is. I love
That's
my
awesome.
job. That's why I say, and every day there's something interesting that happens in the courtroom. That's why I enjoy it. Like you're never going to have a boring day.
Yeah.
Ever.
Yeah. Well, when you go private, you could get a sponsorship with Tuna Blue. We'll, we'll advertise for you right here.
Exactly.
Yeah. Thanks, man. Always a pleasure talking, dude.
Yeah. Thanks for having me on.
Yeah. We'll do it again sometime.
All right. Sounds good.
Later.
Yep.